Perfect.
Yes. So very good afternoon to everyone. And as you had seen on our webinar flyers, this afternoon we have three very prominent cybersecurity and data protection professionals and specialists. And we are going to talk about data protection in Africa, as you know, but we are going to concentrate on the very question of adequacy decisions. For today, we have, first of all, we have Dr. Laibuta Mugambi. He's from Kenya. He's a cybersecurity professional. He's also a chairperson of Kenya Privacy Association and data privacy certified professional. We also have Dr. Samuel Nwankwo. He is also cyber security and data privacy professional specialist. He is at the moment in Hanover University, and we are very happy to have you this afternoon as well. And then we have Ms. Rufaro Mhandu. She's from Zimbabwe. She's an advocate of law advocate. She's also specialized in cyber security and data privacy. So as you can see, we have a panel full of experts for our webinar this afternoon. If I may give you a floor if you want to say a word or two, our speakers. Anybody can start.
Nothing special, just to say thank you for the invitation. I'm looking forward to the conversation today.
Okay.
So thank you so much for the invitation.
We're happy to have you. So before we start our webinar this afternoon, I thought it was really prudent to say a little bit about what is adequacy decision for those who may not be conversant with this terminology. So adequacy decision is sort of a finding or decision that is made by the European Union for countries that are not within European Union area, to sort of certify that a certain country which has low data protection law is fit and has passed the assessment that requires for European countries to be able to transfer negotiating adequacy decision with Kenya. And so because of that, we decided to come up with this webinar to discuss what it means to Kenya and what it means to the rest of African countries and see what this pronouncement means to the rest of the world when it comes to protection of personal data. And so to start today's questioning, I think I will ask, this question is general to all the three of our panelists today, is that given the fact that Africa is the only region among the world, within the world, that neither of the countries have the adequate decision yet to this moment, what do you think this pronouncement means to Africa when they pronounce that Kenya will receive? They are in a dialogue they're talking about giving Kenya the adequacy decision. What do you think that means to Africa as a region? Maybe I can start, ladies first. I can start with Rufaro, if you'd like to say a word or two.
All right, thank you, Patricia. I think it's a good start because it's a long time coming that we have such a stance being taken by the EU, because you find that even countries like Mauritius, they've applied for an adequacy finding to no avail. So the fact that they've decided to consider Kenya within the region, I think it's a good start, I should say. Even though, you know, for most of us African countries, we've been hoping that they make this decision earlier, because you look at countries like Botswana and South Africa that they've already been trading with at a very high latitude. For example, with Botswana, they've been trading with Botswana to the tune of as much as 1.48 million euros. Already, it's something that we've been waiting for, and hoping that, you know, considering the look at 22 out of the 54 countries already have data privacy countries. So it's something that would say it's a long time coming.
Thank you so much. Thank you so much, Rufaro, for your insight. And indeed, I think in most of these conversations, even before the pronunciation that was made last week, most of people have been asking why is, for example, South Africa not yet received the adequacy decision, given the fact that they had the law for a long time, but at the same time they have a lot of trade with European countries. So what's your take, Dr. Laibuta, on the fact that now EU seems to have an interest to provide adequacy decisions in general?
I have to say I'm a bit biased because my doctoral research was on adequacy. How do we determine adequacy? For me, I'm actually surprised, notwithstanding that I'm Kenyan, I'm actually surprised that Kenya is selected as one of the countries for discussion in terms of adequacy. But one thing we need to bear in mind, adequacy is a political process. Why do I say it's a political process? We can look at the EU-US negotiations on the transatlantic rules, and you find that even the latest ones, that notwithstanding that we had Schrems 1, Schrems 2, there's still that issue of access to remedies and how to police the US state agents to access personal data of the Europeans. It's still a sticky issue. But still, the organs of the European Union still promulgated these rules and say that now this is the rules that we are going to use, and quote unquote the US is adequate. And even when you look at what academics have said in terms of how the EU determines adequacy, if you look at critically, there's no framework. Of course, I think it's either regulation article 43 or 45 that talks about what to determine when you're thinking about adequacy, and it just provides a high-level questions that, for example, do you have a constitutional provision? Do you have access to remedies? Do you have a Data Protection Act? Do you have an independent regulator? Have these decisions been made, etc.? So when you look at this across the continent, of course, there are countries, not just Kenya, that have similar, have this kind of framework in the EU. But again, it's also vague how the EU, in as much as when you read the documentation, you'll find that the EU also said it's not a must that the law of the country they're looking for adequacy mirrors the GDPR or EU law. So that tells you, somebody will just say, what's my feeling on this law? So that's what I say. Sometimes it becomes a feeling, and that's why I say it's a political process. But it's not just the EU, even the UK. When the UK left after Brexit, one of the countries that they listed in terms of a country that they want to negotiate adequacy between the UK and the US is Kenya. And one of the reasons was that the UK said there's a lot of trade, there's a lot of data trade or digital years old. But just from my thinking, those are my preliminary thoughts on this.
Okay, I'm going to hold to that thought of this is more of a political decision, because I think there's a lot to be said about that. And given the trends that we see and how other countries or other regions are taking Kenya as sort of an example of best practice in Africa, I think that is a discussion that needs to be tabled and discussed and talked about. But before we go to that, I will hold that thought. I want to ask Dr. Nwankwo, what do you think now that it is the time that EU is coming and showing interest? in providing adequacy decision. We've had laws since 2001, more than 23 years, I think. And as Dr. Laibuta Mugambi said, Mauritius had applied, not even approached by the EU. They applied for to be given the finding of adequacy decisions. They even they were once I don't want to use the word rejected, but they were told they need to align more with the GDPR, and that's why they decided to amend their 2004 law in 2017. So they amended the law to be more aligned with the EU GDPR, so that they get the adequacy decisions back. We haven't heard anything from the EU side saying we are interested or we are in a dialogue with the Mauritius to provide them with adequacy decision. But my question to you is, why do you think now, at this time? Not the question of Kenya, but now.
Well, it's also, I mean, it aligns with commercial political interests of the EU, as Dr. Laibuta said. I mean, there is no hard and fast rule as to how a country becomes fit to receive EU data. It is a unilateral implementing decision, right? And I think it will be a sort of disheartening for a country to apply and be rejected, because what it means is that you subject your jurisdiction to a scrutiny of another country. In the case of Kenya, I think the immediate reason one could see is the recent economic partnership agreement that was, I think, signed around December. And the EU has a policy of not including data protection, privacy issues in those agreements, because sometimes it muddles the water. For example, with China, EU cannot go into any business agreement or negotiation with China and talk about human rights or privacy, as the case may be, because that will be stalled, because the Chinese has a different understanding of all these concepts, right? So in the case of Kenya and Africa, I believe the new outlook of the world is that Africa is the green field now. Africa is the mango is ripe in Africa because the population is there, the talent is there, and I believe whatever it takes to develop a continent to be at par with any other continent is there in Africa. But what is lacking sometimes, one could argue, leadership and the rest. And the EU has this policy now to look for new frontiers, and Africa is perhaps the green field. And if you look politically, you could see this rival between China, US, Europe. The melting point really is Africa. And it is a sort of to their advantage to have a partner in Africa that could be elevated to this height of having an adequate data protection requirement. For me, it is a two-way traffic, right? It doesn't simply lie on one party to say you are adequate. It doesn't mean anything if the second party doesn't have the patience and the readiness to adjust to this investigation. Because what it means is that Kenya too has agreed to subject itself or its jurisdiction to the scrutiny of the EU. I don't know if you've seen the template of how they do this assessment. It's funny. They will investigate almost everything you do. Extra data protection, they will go to your human rights records and not every country really will be ready to subject to that kind of investigation. Some countries really would not even want to be accessed by the EU because for them, it is, why would they do that? It is not relevant because also the threat with some of these countries happen. For example, China. China is more or less the greatest partner with the EU in terms of import and export. But nobody talks about that because for them, perhaps it's not relevant, and China perhaps will not even agree. So in the case of Africa, I think it's political decision, and Kenya has agreed to subject itself to that. It could be positive. Perhaps it could set Kenya as not only, also, you know, in 2021 too, the UK authorities highlighted Kenya as a priority country. So perhaps Kenya in Africa has attained perhaps the criteria set by the EU and perhaps the UK in that case, because the commercial interest is there. Kenya, I think EU is the first exporting partner of Kenya currently, I think. So the commercial interest is there. Kenyan data protection law, I must admit, is up and doing. The decisions from the courts, the activities of the Data Protection Authority, they are being noted globally. And perhaps this is a clear testimony that what they are doing there is being recognized, because this is a unilateral decision. I believe the EU thought of it and decided to approach the Kenyan authority to enter into this dialogue. Generally, I think it brings Africa now to the spotlight that something positive is happening. Mind you, today we have about 37 or so African countries that have passed data protection or privacy law in one form or the other. And I mean, back in 2017, when the EU did an assessment, in fact, they published a communication. Let me see. They called it communication, EC communication on exchange and the protection of personal data in a global world. In 2017, no African country was considered then. In fact, then Kenyan Data Protection Act was not enacted. So it means that going forward, I think Africa is ripe, and this is a positive development if you take it that way.
Thank you so much, Dr. Nwankwo. Dr. Laibuta, I'm gonna pose a question, but for you to think about while I ask Rufaro a different question. Dr. Nwankwo mentioned that Kenya has been identified not just with the EU, but also when the UK was exiting EU during Brexit, that Kenya was one of the countries that was earmarked as potentially being given sort of adequacy by the EU as well. And that was the only African country again. But also there's you say your PhD thesis is about adequacy decisions. And I'm sure you are aware of the decision that was made by the Commission of was it Botswana, I think, last 2-3 years. She published a list of countries in Africa that the commissioner in Botswana considers to be or to have adequacy frameworks for protection of personal data. And within that list, you could see European countries, almost all European countries are there. In Africa, there was Kenya and I think Nigeria, if I'm not mistaken. So given that this background, I would like to hear from you, Mugambi, but not now, just keep the question. I would like to hear from you. Do you think really, apart from these decisions being political influenced, do you think when you consider the Botswana list, that this could also be just a rush that we are following just because Kenya was identified twice by EU and UK, then maybe probably Kenya is one of the countries that feeds or provide for adequacy framework? Do you think in terms of what the list provides from Botswana, what does it say to us as Africans? Keep that question while I ask Ms. Rufaro another question that Okay, what do you think, Rufaro, if you're still there? What do you think this means? Does it mean, of course, Dr. Nwankwo already said that this is the beginning of Africa to be recognized, but we remember we've been here for more than 24 or something years, but we've never been recognized. So what do you think, Rufaro? Do you think Kenya being picked out of 38 countries with data protection frameworks, do you think that is just a coincidence, or is it a beginning? Is it just a single unique case, or is it a beginning, as Dr. Nwankwo said?
I really want to agree with my colleague here, Dr. Nwankwo. At the same time, you see, like what even Dr. Laibuta was saying, that they don't have, EU doesn't have like a structured formula as to the decision that they arrive at, whether there is adequacy, you know, with this adequacy finding. So, and one of the criteria that I saw, the rule of law. So, you know, yes, I agree. Africa is green right now. It's looking attractive. There's so much happening. You look at even countries like Uganda, they've got their case laws and the like, because that's one of the things that they consider. And just like what we were talking about, what Dr. Nwankwo was saying, that Kenya is on the right track, because even with their legislation, with their case laws, and you know, the appointment of the data commissioner, they are attractive in what they have done. So it's a difficult question to answer, really, because of the issues that come to mind when you look at my country, for example. We've been on the backlash, back and forth with regards to human rights violations, the rule of law, and all of that. And we're not the only country that comes to play. We look at Central African Republic, we look at the DRC, you know, and we even look at even Rwanda. Sometimes they are questioned as to how they do their democracy and the like. So, because it's a political decision, I'm really hoping that is a good start. At the same time, part of me is really skeptical, because the truth is, it's interesting that, you know, just in December last year, they had a trade agreement with Kenya, and then now they're talking about adequacy finding as well. So I'm thinking maybe it's because they're in this agreement that they want to make happen. And at the same time, Africa is what's happening right now. So yeah, I'm hoping. That is what I'm hoping for. I'm hoping it's a good start. At the same time, there are all of these issues that come to play. I'm just giving us all, a food for thought to say, is it really? Because for me, I'm failing to answer that question, because I am doubting that in the next 5 years, there'll be maybe more than 5 or 7 countries that would have had some adequacy finding with EU, considering that there has been, since 2013, there has been countries that have been having data privacy laws in place. So that's why I'm doubting it. But at the same time, I'm hoping it's a good start.
Okay, thank you, Rufaro. Dr. Laibuta, if you will allow me to just push again that question, not further, but push it to Dr. Nwankwo, because now what Rufaro said gave me another idea, and this of a question that I think you are more suitable to answer, because you've had a podcast, a very successful podcast, when you are talking about agreements between Kenya and the US. Now we are on the other side of Mediterranean. We're no longer in EU and UK. Now we are talking about the US. So the US also wanted to have an agreement, or to have a contract of some sort with regards to transfer and sharing of personal data between the two countries. And again, Kenya was picked out of, I don't know how many countries in Africa. Maybe there are others, but I think so far, you will correct me if I'm wrong. I think so far, US is having, or I don't know how far is the negotiations with Kenya to have sort of an agreement to transfer and share personal data. So what's your take on that, Dr. Laibuta? But at the same time, what does it mean to the EU announcement last week when Kenya has an agreement with the US for data transfer, and EU also wants to have this dialogue to pronounce Kenya as having adequacy framework? What does it mean? What does it mean to Kenya? What does it mean to the US? And what does it mean to the EU altogether?
Wow, okay. That's a tough question. Now, let me start with you mentioned Botswana. So Botswana has a list. And as you say, that list, I think when it came up, we were all asking the question, how did they come with this list? And nobody, even our colleagues in Botswana, could answer. So we hazard a guess that maybe someone just looked at the laws and says, this one looks adequate, this one looks adequate, and that's what it. And I think that's what Nigeria did, because there's a case, the Ikigai case, that challenged a similar list. And the High Court in Nigeria said, no, hold on. You can't do adequacy in this regard. In that list, there are even countries that really do not have functioning data protection authorities. So those two cases, what it shows you, it's quite subjective. Like I said, like for example, in my doctoral thesis, I propose what I call an objective framework for determination of adequacy, because I feel that adequacy should not be subjective and should not be mostly a political process. There should be an objective checklist which you could look at. For example, when you look at Article 45 of the GDPR, 45.2 is the one that talks about what you look at when you determine adequacy. And it talks about rule of law, respect to fundamental rights, relevant legislation, concerns to public security, defense, issues of criminal law, professional rules, security measures, existence of a functioning and independent supervisory authority, etc. So it provides broadly what you're going to look at. But what is it you're looking at, for example, in the law? So if you're saying a country has a Data Protection Act, fair enough, it has. But how do you analyze that act? What should be on your checklist to analyze that? Is that the fact that it has an act and it has an independent data protection authority? Now, recently, in September last year, the minister in charge of ICT and the digital economy in Kenya appointed a task force. And this task force was to look at all laws within the digital economy, including the Data Protection Act and the cybersecurity laws, any law that touches on the digital economy. And one of the persons who are proponents of adequacy of the EU, they are saying, please do not amend the Data Protection Act so that we get adequacy. They're like, if we amend anything, our adequacy discussion might end. But in my thinking, especially in my academic work, I have identified so many gaps. For example, in my thesis, I identify 20 major areas that need amendment of our Data Protection Act. 20, and this is just me within an academic research, which means if more Kenyans look into this, perhaps there could be even more. But the argument is that let's not touch the Data Protection Act as yet, so that the EU can grant us adequacy. You see, so there's that push. That's why I say it's a good thing. And granted, the Kenya Data Protection Act that was that came effect in November 2019, the appointment of the Data Protection Commissioner, and 1 year later, the Commission has done tremendous work. To be honest, I mean, when you look at the Commission, they have established administrative structures. There are offices in the regions. I think there are 3 offices in 3 towns in Kenya. They have issued penalties, administrative notices. They're training people. They're carrying out sensitization. So there's a lot that has been done. But you see, adequacy, one of the pillars of adequacy is looking at the law. And the question is, how do you analyze the law? So for me, using my tool, the tool that I propose for adequacy if Kenya was to do a self-assessment, then we need to amend the law to improve it in certain areas. Let me mention some areas. For example, there's a provision in Section 8 that says the data commissioner shall collaborate with national security organs. What is collaboration? In Section 51, it talks about exemptions, and one of the exemptions is national security. It doesn't define what exactly is national security. When you look at the GDPR, it says when it talks about national security, it breaks it down. Thirdly, our law provides for a big role for the cabinet secretary or the minister in charge of ICT. So you find the minister has administrative roles, also issuing guidance notes, issuing the regulation. So there are two pillars in terms of regulation. When you look at our principle, for example, the issue of accountability and security does not feature in our data protection principles as it appears, for example, in under the GDPR. When we look at issues of localization, our provisions under the regulations on localization are quite vague, because they say you can either keep a copy within the country or have all the data there. So which is which? So whichever you do, you comply, which is quite troublesome for the. So ideally, when you look at it, I mean, I would love that Kenya to get adequacy, but you see, as I said, I am biased because I've done deep dive academic research on this. And if I was to identify, I would say Kenya needs to carry out, like what happened to Mauritius, Kenya needs to amend its laws and improve on certain areas before that adequacy is granted. But remember, we also said, and I think Dr. Nwankwo and also Rufaro have agreed that by and large, it's also a political process. Now, going to your other question on the deal between Kenya, the US, and the EU. Now, this is the elephant in the room, to be honest, in Kenya. For those who are Kenyan and know this, is that on one hand, Kenya, of course, everybody wants to say our law mirrors the GDPR. And of course, now, recently, I think the US, and I think there's a conference happening, I think, in either Japan or Korea about the cross-border rules. And the U.S. Department of Commerce is pushing for these CBPR rules to be the certification, especially so that American companies can easily operate within the African region. But on the other hand, the EU is pushing that Kenya adopts a strict GDPR kind of way. And when you look at even our trade agreement, our trade discussion between Kenya and the US, on issues of digital trade and the issue of data flows, it says there should be free flow of data. You see, like what we have in the African Union Digital Protocol, that this protocol shall ensure that there's free flow of ideas. So, and I think as many academics are saying, that protocol reads very American-ish, okay? So the question is, the question and the elephant is the room, which way will Kenya go? Because if we go the EU way that protects data, that we look at the fundamental rights and freedoms of the data subject, but the US is saying we need free flow of ideas, we need unrestricted trade operations, and we need unrestricted environment for businesses to thrive, then Kenya is there. And you'll find that, for example, our president is going to the US to meet President Biden, I think, in a few weeks. The EU has made this pronouncement. So you see the kind of dilemma. But what I say is that people are feeling that perhaps, long time ago when I worked in international development, in one conference, somebody said, if something works in Kenya, it's easier to sell it in other countries. So probably they say, when they look at it politically, and I think Dr. Nwankwo mentioned, is that so if Kenya, they say Kenya is adequate, then it can easily be sold out there that you see what Kenya is doing. And if Kenya is doing this, then it should be right for your country also. So those are some of the questions and issues that just come to my mind when I analyze this situation.
Thank you so much, Dr. Laibuta, for this very well explained situations. I would like also to say to those who are listening that if you have a question, you can already write it on the chat, or we have something like, after I ask this question to Dr. Nwankwo, then we can open the floor for questions. If not, we can continue with our discussion. So a question back to you, Dr. Nwankwo, is also based a little bit from what Dr. Laibuta said just now, that now Kenya is in the crossroads. There's EU way, there's US way, and Kenya is doing business with all two parties. And given that matrix, do you think African countries should really strive for adequacy decisions from, it doesn't matter if it's EU, US, within our own boundaries? Do you think it's necessary for the protection of personal data and flow of personal data that African countries try to align their framework with a certain foreign framework so that it can be pronounced as adequacy framework for, let's say, data protection or data sharing or data flows? Do you think it's necessary, or should we, or each countries or African Union as a regional organ should come up with its own way of measuring those assessments?
Thank you very much, Dr. Boshe. You know, this is a power play. Now, if you look at it critically, a single country that has in its law that data from its jurisdiction cannot be transferred to another country if that country does not have imposed an adequate level of protecting personal data. It carries no weight if you don't have the economic political power, for example. I'll give you the instance of the UK, for example. Since they left Brexit, they've not concluded any single adequacy arrangement. In 2021, they mentioned Kenya, I think India, and some other countries. Since then, more or less, nothing has happened because it is not, they don't, strictly speaking, it is not attractive to adjust your law to another country's law if you're not benefiting anything. In the case of the EU, you may know or you are aware that almost all the African data protection laws mirror either the GDPR or the previous data protection directive. But that is not the whole case. It is just an aspect of the formula. By the way, there's actually a formula for the commission to do this assessment. They said it in 2017. I can read it here. I have it on my screen. They identified 4 criteria for their adequacy decision. Number 1 is commercial interest, the commercial relationship with the third country. Number 2 is the extent of personal data flow. And if you look at it critically, Africa does not have this digital infrastructure that attracts data flow from EU to Africa. The trade agreements may be in physical goods, for example, raw materials. They really do not attract a huge amount of personal data. Those agreements could be signed without much personal data transfers being an issue, really. Now, the third criterion here is that the country in quotes is a pioneering example within its region, right? For example, when Japan and Korea amended their data protection laws, by 2017, the European Commission identified them as examples from their region, I think Asia there. Now, the fourth one is the political relationship with the third country. So there is actually a criteria for this assessment. Now, the UK actually has a template of how they do this assessment, and it goes into detail as to what they will assess. For example, if your data protection law, it goes from the principles to how the supervisory authorities enforce the laws, how much fines they've issued over a period of time, blah, 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 blah. A long list, really. So the question is, for whose interest would one subject his jurisdiction to this adequacy assessment. If there is no commercial political interest, usually it's not worth it. And some countries actually in Asia, for example, will not subject themselves to this adequacy rule because the nature of data flow from those countries to the EU are so insignificant. But if you contrast it with places like the US, where the major ICT infrastructure is established, the cloud computing companies, Amazon, Microsoft, name them, there is this desire to have this agreement so as not to forestall this digital data flow. Even when the US privacy laws are not more or less equivalent to that of the EU, they go ahead to certify certain aspect of commercial activities as having data adequacy provision. Contrast it to Africa, we do not have such muscles and the infrastructure is not there. That is why perhaps even in the next 5 years, this current negotiation may not happen with Kenya. It may take more than 2-3 years, I'm sure. Also mind you that this is subject to a judicial review. It is a difficult process because you are aware that the US-EU framework has been nullified twice by the court. So it is not an easy task. I will encourage the Kenyans to do the best to achieve it. Perhaps it's a good fit, but I'm not sure in the next years, 1 or 2 other African countries would pass these tests because it is a unilateral test. The commission may find you adequate and the court will say, no, there is this, that. So to an extent, it's not attractive. Many countries, mind you, this is just one aspect of the data flow. You know, there is another one, the data protection law for law enforcement authorities. That's directive. Could you believe that it is only one country that the European Commission has adjudged to be adequate for that law? And that is the UK because of Brexit. So sometimes these things are not attractive. They are just there for, I don't know. For me, sometimes it's not worth it. Now, coming back finally to the African region, you know, the problem is that we copy some of these laws verbatim. So if you check each and every of our African data protection laws, there's this provision of prohibition of cross-border transfer and the exemptions, including this adequacy finding. But if you check the criteria for this adequacy assessment, it varies. For example, in Nigeria, the Attorney General of the Federation could do it under the NDPR. NITDA could do it under the NDPR. Under the NDPA, that's the Act of 2023, it is the Nigerian Data Protection Commission that will do it. Now, if you check the other African countries, I think there is one where the minister responsible for that unit could do it. There is one where even the data controller itself is expected to do the assessment. So it is not harmonized. And if there is no harmonization at the regional level, it will be very difficult for Africa to talk of adequacy because no one country will subject itself to another African country, for example, for you to be adequate. There must be a regional harmonization because that is what the GDPR actually came to do. All the 27 European countries had different requirements, and the GDPR came at the regional level to harmonize it. That is what is lacking in Africa. And if we have such a regional harmonization tool, then it will be attractive at the regional level for the EU, for example, to have this agreement with the AU. And you see that as long as you are within that AU adequacy framework, then automatically the agreement between AU and EU will affect you and it will be easy. So I believe in the next 5-6 years, we may not have more than 1-2 African countries in this list. because of the difficulty actually of having this assessment.
Thank you so much, Dr. Nwankwo. It's something that when you are speaking that came into my mind in relation to what you said, and also there's a comment here on the chat that say it is the high time now we have our criteria on the African continent on adequacy. Adequacy is supposed to be subjective. The African Free Trade Agreement must think of a protocol on this. So when I read this and in relation to what you've just said, I quickly thought of the fact that if and when Kenya or any other country in Africa is granted adequacy, what does it mean to the free trade agreement? That means instead of supporting the framework, the free trade framework, it will create some hindrance, because now Kenya will be pulled on the EU side. It will have to make an assessment on which country Kenya will trade with based on that assessment. So I think this is a very complicated matrix that African countries need to think very carefully before enter into certain agreement with countries beyond Africa, especially in terms of adequacy. Before we proceed, there's a question from Daniel Baitwabo. Sorry, I cannot pronounce your name. Daniel Baitwabo, yeah.
Thank you, Boshe. Can you hear me?
We can hear you.
Can everybody hear me?
Yes, you're loud and clear.
Yeah, thank you very much for this timely discussion. Unfortunately, I joined a few minutes when you had started, but I have some reactions and a question. My reaction goes to Nwankwo. I think it is high time we had a regional body that, in respect of data protection, that can look into the requirements for adequacy. Now, why do I say this? We have so many blocks in Africa, and each block has always its interest. Now, if we get a regional body, whether it can be one body or whether we decide to do it regionally, ECOWAS, SADC, EAC, whatever, I don't know how best we can do so that we have requirements that stick to our local setting. That is my issue. Requirements that stick to our local environment. We don't have to, as I think it was Deningo saying, we don't have to transplant the English oak into our legislation. Even if you transplant it here and you bring it here, it won't work. That is my reaction. Now, my question, I think Laibuta can answer. That the section 2 of, I think it's 45, Article 45.2 of the GDPR on adequacy. Now, who sets the parameters of these principles that they say, rule of law, human rights? Who sets the parameters? Because what constitutes rule of law possibly in Nigeria or in Ghana might be different from what constitutes rule of law in Kenya, in Uganda, or in Tanzania. We have what I may call, excuse me for my better lack of word, controlled economies. What constitutes human rights in a controlled economy might be different from what constitutes human rights in a liberalized economy. But if we want to use the one size fits it all, and you have someone else telling you the parameters of what rule of law is, I think we are going to have a problem there. And that one will not agree. I'm sure a Nigerian and a Ghanaian will never agree what rule of law is. I'm sure a Ghanaian and a Kenyan and Tanzanian might not agree what rule of law is. Each one will speak to his own environment, his own setup, and even his historical background. These countries have been built on different historical perspectives. For instance, if somebody talks about rule of law from the Tanzanian perspective, Somebody might look at the union perspective. Somebody might look at mainland perspective. So what are we going to do in this aspect? I think Laibuta and Nwankwo, you can shed some light on this. Who sets the parameters? That is my biggest question. Who sets the parameters? Thank you. I'll ask other questions as we go along. Thank you.
Thank you, Daniel.